Welcome to this edition of Ed Talks. It has been a couple of weeks. Been caught up on other stuff, but thought I'd take the opportunity to have this Ed Talk outdoors. The ranch got some rain finally, so the fields are turning green again and the animals are out, and it's not 108 degrees anymore, and other than the flies, it's a nice day to be outside, so I figured I'd take it outside and do this edition of Ed Talk out here. I want to talk about federal courts today. A little over a week ago, I had someone come in who was particularly anxious. That's not unusual. People are anxious when they come to see me, but he was anxious in particular because he was charged in federal court, and he thought federal court, when he thought about federal court, that whole thing terrified him. So it took me a while, but I was able to explain to him how being charged with a crime in federal court is not substantially different than being charged in state court, not as so far as he would be concerned. And I thought I'd take this opportunity in this Ed Talk to talk about that. I get lawyers who ask me questions about that too. They're also nervous about federal court, going into federal court, and I think that's just a matter of unfamiliarity. This video is intended to kind of relieve some of that anxiety for everybody involved. Explain what it is. What's different about federal court than state court? All right, well, let's start with the very first. Most of the time, I say most of the time because nothing's always works this way, but most of the time an individual before he goes to court is going to be in custody and brought before the magistrate in a preliminary appearance, and it's at that point where the decision is made whether or not he's going to remain in custody. Now, I say not all the time, because if somebody comes to see me and we know that the FBI is investigating, and I know the assistant U.S. attorney, and I can develop a dialogue with the agents and the U.S. attorney, it may very well be that we can negotiate a summons and an arrest doesn't have to be made. But usually when someone is being investigated by the federal government, by the FBI, ATF, Homeland Security, IRS, what have you, they're not going to know they're being investigated until they get a knock on the door from some FBI agent, or two FBI agents who want to talk to them about certain deposits they made in a bank or what have you. And then a lot of times they don't know anything's going on until they get arrested and they're brought down to the detention center or the jail, what have you, and they're brought before the magistrate. So most people in state court, when they're charged with a crime, they're going to get bail set for them, and then they're going to make bail, and they're going to go to a bail bondsman, and that bondsman's going to post bail for them, they're going to get out. By the time they get to court to address the case, they've already gone through that process. In the federal court, it's different because it's kind of backwards. You're going to go before a magistrate on a preliminary appearance, and that magistrate then is going to make a determination about whether to release you on conditions, or if the government moves to detain, whether to have a detention hearing. So the process goes something like this. You go into the magistrate either by summons or in custody, typically in custody. And then the magistrate is going to tell you what you're charged with. You may not have counsel at that time, so the magistrate is also going to establish whether you've hired counsel or whether you need one appointed to you. And then the magistrate is going to turn to the government agent and say, hey, or the government lawyer, and say, do you move for detention? Do you want this guy detained? Most of the time, the government's not going to make a request to detain you. All right? If you've got the typical bank fraud case, money laundering, some other financial crime, the government's not typically going to ask that you be detained. They're going to ask for conditions, and the judge is going to apply those conditions if pretrial recommends them. But you're going to get out. You're going to be released. The difference between the federal system and the state system is that it's not really going to be a bail bond that you're released on. It's a release with conditions. Now, the judge may very well tell you that you are going to owe $50,000 if you don't show up in court. But that's going to be unsecured most of the time. The judge can require security, can require a bondsman, can require you to put cash down in the registry of the court, or put up your home or what have you. But that's not always going to be the case. That's not the typical case. Most of the time, the magistrate is going to release you with an unsecured bond of some sort, and tell you what your conditions are, and then the ball gets rolling in the system. That's different than in state court. You might find yourself getting out of being released in federal court with no money down, whereas in state court you've got to dip into the coffers to try to get out on bail. It's just a more humane, I think, way to do it, and that's one of the benefits of federal court. One of the downsides of the federal system is you may be in custody when all this is going on, but that's not too dissimilar from state court these days, where bonds aren't automatically set, at least in Harris County. So nothing to be anxious about there. If you have counsel, your counsel may be able to negotiate even an easier swim through the system initially. The second thing that's different in federal court is the formality. It's a little bit more formal. When you go to court in district court, when you wind up in district court, you may find yourself to be the only person that's set on that particular time, or maybe one of only 3 people set at that particular time. When you go into state court, it's basically a carnival. You've got hundreds of people waiting to get into the court. It's hard for the judge to pay any attention to you. It's hard for the prosecutors to pay any attention to you. But in federal court, they're not burdened by that. And so what will happen is you'll go in, you'll see a certain formality in the proceedings. The court rooms are more majestic. The judges are more formal. There's certain little things that go on, knocking of the door before the judge comes in, the loud order to rise, some of the language that's used is more formalistic. But it's nothing really different than what you're dealing with in state court. It's just a matter of them having the ability to pay more attention to your case. That's the way you should look at it, at least. Your case is not being treated more importantly than any other case that comes in, but it's not being treated with less importance, which is kind of a big deal, and I think that's a good thing. So that's the second thing that's different in federal court. Another thing different in federal court, but it's not something you need to stress over, but it is different, is plea bargaining in federal court. Now, I have already done quite a bit of quite a few essays and some talks about when a plea bargain or plea negotiations, or a plea bargain is something that should be considered over a trial, or the difference between a plea bargain and a plea offer, that kind of thing. So all of that applies in federal court as well. The difference in federal court versus state court is that you're usually not going to know precisely what your sentence is before you agree to plea. And that's because in the federal system, the judge, defense, the U.S. attorney are all constrained by the federal sentencing guidelines. Guidelines have been promulgated by the Sentencing Commission. They have been figured out and put in a book because Congress decided that individuals who are charged with similar crimes should be sentenced similarly. If they have the same criminal history, if the offense is the same, if the aggravating circumstances or lack of aggravating circumstances apply, then those individuals should be sentenced similarly. So they have given authority to the Sentencing Commission to figure out what that is. It's in a book, and it's available online. It's available to everyone, and we all have to abide by it and go by it to determine generally what the range of sentence would be for a particular crime under the certain circumstances that are understood to exist for that particular crime. The judge has to consult the guidelines. Doesn't have to go slavishly and do whatever the guidelines say. At least in the last 10 years or so, that hasn't been the case. But they have to consult it, and my experience has been that they usually are going to sentence within those guidelines. They can vary up, they can vary down, but they're going to take those guidelines very seriously. The U.S. Attorney, they're going to be limited by those guidelines. They may very well think that you deserve less of a sentence. But it is the only way to lock in a sentence and lock the judge into a sentence is a special plea that is rarely done, a C plea that's rarely done, and judges don't like it. They don't like to be locked in. So that's another reason it's rarely done. So they can estimate the range as well. So the defense can estimate the range of where the sentence is going to be. The U.S. government, they can estimate the range of where that sentence is going to be, and then ultimately we may all agree that that's the range it should be, and yet U.S. probation may decide that a particular enhancement applies, and it goes over to the judge, and the judge may disagree with us or disagree with probation. Bottom line is, there's no way to guarantee the exact sentence, with rare exceptions, in federal court once you plead guilty. So it's a little different. If in state court your lawyer goes up and he haggles with the prosecution and they all agree, okay, 3 years probation or 2 years in prison, whatever, and you've agreed that that is a plea bargain and you avoid going to trial and being prosecuted and face higher penalties, and you take it. Right? You know what's going to happen. It's written in written form. It's 2 years. You're going up there. Judge says 2 years. In federal court, we don't get that. Now, there's a lot that your lawyer, your defense attorney can do to cut the odds in your favor. In some districts, I haven't experienced this in the Southern District, but in some other states and in some other districts, the U.S. Attorney will actually put their guideline formulations in the plea agreement. And that has quite a bit of force when it gets to the judge and probation, because they already see what we've agreed to. So it's persuasive, but you're not going to get that all the time. And in any case, the probation still doesn't have to agree to it, and neither does the judge. You may have the U.S. Attorney and that your defense attorney may agree that a particular enhancement should not apply, say management of some sort, supervisory role of some sort. It shouldn't apply, and then it gets to probation, and they read the FBI's report, and they decide that it does apply, and then the judge agrees, and then here we go. You know, I had that happen to me in the Valley once on a gun enhancement, where everybody agreed that a gun doesn't apply, and then the judge did it anyway. All that did was create an appeal, but it happens. But there's a lot that your lawyer can do to cut the odds in your favor. You can still make a reasonable, informed choice about whether you want to plead to the case based on how the plea is formulated, certain provisions that are put in the written plea agreement, and then if getting the prosecution to agree to any objections you may have to some of the enhancements. There are things that can be done. There's a lot of things that can be done, and it's far and away too extensive to go into with this particular Ed Talk, but you'll be able to make a decision, but you'll never know exactly what your sentence is going to be. There's some good to that as well. Reality is, the inability to determine what the sentence is going to be may inure to your benefit as well. The judge could very well vary downward in your case, or the judge could very well find that enhancement doesn't apply in your case. I had one judge in federal court one time who, I think what he did was he horse traded. He knew that my client needed to get into the drug treatment facility, and knew that it was going to be difficult to do that with a gun enhancement. And so even though we had some agreement, he traded off the gun enhancement for a managerial enhancement. I believe it was I don't remember exactly which one, but it kind of it equalized, got rid of the gun, and then recommended the drug treatment that we needed. So the judge has a lot of power to do whatever he or she wants, and it may inure to your benefit. So it's not as ominous as it sounds. You'll be able to get through it. It's just that it's not going to be, no one can tell you exactly what's going to happen. So that's different in the federal system as well. Probation. Probation's rare in the federal system. It's very unusual for you to get probation in the federal system. You're going to have a guideline, probably less than 12 months to get there. If you get close, your lawyer may be able to negotiate maybe some changes in the enhancement, or maybe the charge, or what have you, to get you under there. But it's an unusual, it's a unicorn. It's an unusual situation to get probation. I've done it more than once, but it was always an iffy proposition. If your lawyer says that he can't get you probation, that's not true. But you have to understand how rare it is when you make that request in federal court. State court, they give it away like candy. So it's hard to imagine, but not so in federal court. Although I will say this, in recent years I've seen probation given more and more in federal court. I don't know whether that's an attitude change or I just got lucky, but there you have it. Don't expect probation in federal court. The trial in federal court, it's more formalistic, and what I mean by that is it's just you. If the judge says you're starting at 9, you start at 9, and you got to be there for that particular event. That's not true in state court. In state court, if the judge says you're starting at 9, you sit there at 9. By 11, when the docket's done, they may call you up there and you put on your next witness. So that's different. It's more formalistic. Nobody else is there except you. They've cleared the docket. They've cleared the courtroom for you. So it's more formalistic in that regard as well. If the judge says that you're set for trial on November 9th, you're going to trial November 9th unless there's a continuance of some sort. So that's different. The investigation is different. When a federal agency investigates you for a federal crime, they usually take their time and make sure that all their ducks are in a row before they charge you. And what I mean by that is that they're going to make sure that they have every method of escape covered before they charge you. Any possible defense they're going to try to hypothesize, and they're going to investigate. They're going to talk to all witnesses. They're going to memorialize it. The witness statements are going to be memorialized. They're going to make sure that they've got all the evidence in proper evidentiary form, ready to be presented to the court. There's a reason for that, and that is that there's a speedy trial requirement in federal court that's pretty solid. If you so choose, you can make the government go to trial within a few months, and they're not going to be wanting to go to trial if they don't have their evidence ready. And it's not easy to get bank records into evidence if they're not in proper form. It's not easy to get cell phone records into evidence if the forensics haven't been properly prepared, witnesses haven't been gathered. They're not going to want to charge you if they think there are co-defendants. They're going to want to figure out who they are first so they can put all of the co-defendants in one indictment. Everything is kind of buttoned up before you get to court. That's different than in state court for obvious reasons. In state court, what's going to happen is a state offense is going to start because somebody calls 911 on you, or the cop sees you committing an offense, or etc. The arrest is typically made. The investigation's done after the fact. But there may be more investigation, but you're in the middle of the court system before that's done. So it's different, and that's may have an impact on your case. But you're going to find that by the time you get into court in the federal system, the case has already been prepared, and you're going to have access to all that. Time limits. Well, there are time limits. You're going to have a docket control order that's going to have time limits, unless you're forcing a speedy trial. Those time limits are going to change in time. It's not unreasonable to expect that a federal case may last a year before you decide that whether to plead or whether you're before you're sentenced or whether you wind up going to trial. It may be a year, it may be longer in some cases, especially if co-defendants keep getting added to the case. Co-conspirators keep getting added. That always lengthens the process. State court may be a little bit longer than federal court, but it's not going to be substantially longer, at least the way it seems to be going lately. So those are the main differences, but nothing for you to be anxious about, and nothing that you can't handle, and nothing that's going to make the event more unbearable than it would be in state court. You can manage it, and certainly, hopefully, your lawyer can as well. All right. Well, if you have any questions, feel free to call me. You've got my number, and I'll be happy to answer any questions you may have. I hope you don't ever have to call me, but if you do, I'll be happy to help out. I'll try to move these Ed Talks around as we do it, and I'll see you next week.